Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering college and accuser panic after $110 million lawsuit for false claim of assault. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. I've done a few stories on false claims of racism and false claims of sexual assault. And these stories really underline why it's so important to have due process with any kind of complaint. Just because someone makes a claim doesn't necessarily mean it's true. Doesn't mean it's not true. That's what due process is all about. If we don't have due process, we can never have equal justice under the law. And the system is never going to be perfect. But the system has to at least try to treat everyone fairly so that an accuser and an accused both get a decent hearing. I received an email about a previous video I did talking about a false accusation against a college student. The email explained how this happened to him. The police literally showed up at his door, told him he's not to go back to school, and that he's being accused of a crime. He explained in his email to me that this was someone who pursued him that he said he was not interested in, and then she made a claim against him. This really damaged his whole life. Now, whether or not it's true, I don't know. I'm not Mr. Due Process, but I am concerned about due process, and it is a real thing. So let's go on with this story and find out what happened. This story, which took place at Yale, is one of the most unique stories I've ever read about the subject. From the New York Times, how a Yale student's assault accusation exposed her to a defamation lawsuit. The woman's allegation led to the expulsion of Saifullah Khan, who was acquitted in a criminal trial. His lawsuit is now challenging these disciplinary hearings. From Title IX for All, Khan versus Yale, a momentous decision, a defeat for false accuser advocacy. From Ms. Magazine, sexual assault accusers can be sued for defamation. This will discourage survivors from coming forward. And that's a tragedy. If someone is a victim of assault and they can't come forward because there are too many other people filing complaints that are not legitimate complaints, look at what it does to the system. This is why due process is important. It protects everyone, all of the legitimate accusers and the people that are being accused that didn't actually do it. From the New York Times, how a Yale student's accusation exposed her to a defamation lawsuit. In a 2018 disciplinary hearing at Yale University, Saifullah Khan listened as a woman accused him of assaulting her after a Halloween party in 2015. The woman, who had graduated, gave a statement by teleconference to a university panel, but Mr. Khan and his lawyer were not allowed in the room with the panel, nor could his lawyer, under the rules of the hearing, cross-examine her. Instead, they were cloistered in a separate room as her testimony piped in by speakerphone. He felt, he said, quote, "There was absolutely nothing I could do to change my situation." As he feared, Yale expelled him. Mr. Khan's criminal trial months earlier was markedly different. His lawyer cross-examined the woman in many ways that horrified women's rights advocates. How are you dressed? How much did you drink? Did you send any flirty texts? And unlike the Yale hearing, the prosecutors had to prove his guilt beyond a reasonable doubt. After barely 3 hours of deliberations, Mr. Khan was acquitted. The difference between those two hearings in process and outcome led Mr. Khan to make an unusual move. He sued his accuser for defamation for statements she had made during the Yale hearing. That lawsuit, filed in 2019, is challenging the way universities across the country have adjudicated such sexual assault hearings. Normally, such a lawsuit would not have had much of a chance. In Connecticut and in other states, witnesses in such quasi-judicial hearings carry absolute immunity against defamation lawsuits. But the Connecticut Supreme Court in June gave Mr. Khan's lawsuit the green light to proceed. It ruled that the Yale hearing was not quasi-judicial because it lacked due process, including the ability to cross-examine witnesses. Quote, "For absolute immunity to apply under Connecticut law," the justices wrote, "fundamental fairness requires meaningful cross-examination in proceedings like the one at issue." And the idea is to have both sides present what they have to present. Let them make their statements. Let attorneys ask each of them, okay, well, what about this? What about that? And to really test their statements. If you don't test the statements, if you don't have cross-examination of witnesses, the truth doesn't come out. That's why we have due process in court systems. You have to test people's statements, otherwise you'll never know what's true. Mr. Khan's lawyer, the court said, was effectively reduced to the role of a potted plant. The decision applies only to cases within the state, but it's reverberating at universities across the country. College officials consulted their own state laws, checking whether their disciplinary hearings could leave witnesses vulnerable to defamation lawsuits. As they should, because here they are encouraging witnesses, come forward with your story, we'll believe you no matter what. But at the same time, you can't say that to people and put them in a position that they may be sued. The decision complicated an already electrified debate over how colleges handle allegations of sexual assault on campus in a way that is fair to both parties. Title IX, the federal education law, governs how universities should handle sexual assault hearings. The Khan hearing was governed by an Obama-era guidance which discouraged cross-examination. In 2020, the Trump administration reversed those guidelines and mandated the practice. In a situation like cross-examination, if there are borderline cases, of course it's more likely an accuser might not come forward. But at the same time, you have to determine what really did happen and what people's points of view were. Otherwise, you've got people that their entire life is ruined because you didn't go through that adversarial process. You really have to have the due process. Universities are expecting that the Biden administration will broadly overhaul Title IX again. In the case of campus sexual assault hearings, it is expected to hew closer to Obama-era guidance and make hearings, and therefore direct cross-examination, optional. The Education Department said a Title IX review is currently in process. But the threat of defamation lawsuits like Mr. Khan's could mute the impact of the Biden administration's expected change. Women's rights advocates say that some students who file sexual assault claims under Title IX could face a difficult choice. They could choose to forego being cross-examined, but open themselves up to defamation lawsuits. Or they could protect themselves from such lawsuits, but have to submit to an interrogation during these campus proceedings. Quote, it's highly possible that many survivors are going to say, well, maybe I won't report at all if these are my two choices, said Elizabeth Tang, a lawyer with the National Women's Law Center, which co-signed an amicus brief in the Connecticut case. I think that's really damaging and will result in a chilling effect on survivors. But to Mr. Khan and his supporters, the court decision underlines their belief that colleges are ill-equipped to adjudicate something as fraught as an assault accusation. Quote, it is fundamentally unfair to take a person accused and put him in a situation where the accuser is believed and pandered to and the person's right to defend himself is minimized, Norman Pattis, a lawyer for Mr. Khan, said in an interview. That's just not American. 2 hearings, 2 outcomes. According to a police affidavit, the woman, then 21, was separated from friends after an off-campus Halloween party in 2015. She said that she was drunk for the first time, and Mr. Khan, an acquaintance, sat with her that night as she repeatedly got sick. The woman said she woke in the middle of the night to find Mr. Khan on top of her. She tried to push him off, she said, and in the morning found herself without clothes, even though she remembered lying down fully clothed. But what you did to me last night was wrong, she told Mr. Khan, according to an affidavit. You should leave. During the criminal trial, the lawyers challenged that account, saying that it was consensual. In the cross-examination, they asked questions such as, why did her memory blank on certain details but not on others, like the assault itself? Why did she send Mr. Khan what they called flirty text messages before the alleged assault? And why did she wear a black cat costume for Halloween instead of a more modest one, such as Cinderella in a long flowing gown? The woman, who has been called Jane Doe in the defamation case, did not respond to a request for an interview. But to women's rights advocates, that cross-examination proves their point. The practice is used to intimidate and re-traumatize the victims. They also say the hearings already have plenty of due process rights, including the ability to respond to the investigator's report and submit written questions to the hearing panel. Allowing cross-examinations further deters sexual assault victims from reporting, said Ms. Tang of the National Women's Law Center. Of course, it's going to deter people from making a claim if they're going to be held accountable for that claim, but we have to have accountability in society. There's no way around that. And that is going to result in certain people who are victims not getting justice. It's also going to result in people being accused of things they didn't do, not being accused. Quote, the vast majority of victims are not reporting what's happening to them, she said. It's still really hard to come forward and talk about what happened because survivors know about the retaliation they're going to face, not just from their abusers, but from the larger community. The Connecticut Supreme Court's decision did not address the merits of Mr. Khan's defamation case. The court was sympathetic to the argument that protection from defamation lawsuits helps victims speak candidly with administrators. Ultimately, however, the court found that the Yale hearing had procedural shortcomings, including the lack of cross-examination, not placing witnesses under oath, and not giving a transcript of the proceeding to Mr. Khan. I mean, you gotta give the guy at least information on what he's being accused of, and his attorney should be able to ask questions of the person making accusations against him. That's not fair. Andrew Miltenberg, a lawyer who usually represents the accused, said that cross-examination during Title IX hearings is necessary for fairness because the proceedings are already tilted against the accused. Campus investigators are not always trained in evidentiary procedure, and there is a lower standard of guilt than in criminal proceedings. In the Kahn hearing, the bar was set at a preponderance of evidence rather than beyond a reasonable doubt. Although the accused may submit written questions, that is insufficient, Mr. Miltenberg said, because they are vetted by a hearing committee and are sometimes reworked or not even asked. But Joseph Vincent, an advisory board member of the Association of Title IX Administrators, expressed skepticism about the value of adversarial cross-examinations in campus sexual assault hearings. He said they're meant to test the credibility and demeanor of the accuser under pressure, but they're basically worthless at getting to the truth. The practice rewards those who can't hire the flashiest attack dog attorney money can buy, he said. Defamation lawsuits are a strategic move. The Trump administration rules which currently govern these hearings require cross-examinations and other procedural safeguards. This would have protected Mr. Kahn's accuser from the defamation lawsuit. The cross-examination protects the accuser and the accused because it lets people know, look, we're going to be testing your statements in any proceeding. You must be prepared to have your statements questioned if you're going to make an accusation. Naomi Schatz, a lawyer who has represented accusers and accused in other hearings, has noticed an uptick in such suits, but they're uncommon, she said. The accused usually wants to move on, especially if the case is not public. Mr. Kahn's case had received significant news media coverage, including in the Times, before he filed his lawsuit. Quote, "It's a huge emotional and financial burden to be dragged into a defamation lawsuit," she said, citing the successful lawsuit by the actor Johnny Depp against his former wife, Amber Heard. Nobody wants to be in Amber Heard's position, especially as a young college student without financial resources or social capital. For his part, Mr. Kahn, who was originally from Afghanistan, said that he was pleased with the Connecticut Supreme Court's decision, but he said he doesn't believe a cross-examination would have changed the outcome of his hearing. There was too much intense public pressure, he said, at the height of the Me Too movement. Mr. Kahn, a neuroscience student while at Yale, never earned a bachelor's degree. He's suing the university as well for breach of contract and infliction of emotional distress, among other claims, and he's seeking $110 million in damages and the opportunity to finish his degree. Yale took away my 20s, he said, but his larger mission is to abolish campus Title IX hearings. And he is traveling the country, conferring and strategizing with other students accused of assaults. If he wins the defamation lawsuit against his former classmate, he said that he will disseminate her name and facts about the case online. His name will always be connected to the case, and hers should be too, he said. But Mr. Kahn's defamation lawsuit, now due back at the U.S. District Court in Connecticut, is far from a slam dunk, said legal experts. Quote, "It's not that Kahn will win," said Mr. Vincent of the Association of Title IX Administrators. "It's that Kahn can run up the bills and run out the clock, such that it's no longer feasible to defend oneself. Those filing complaints may have to make a cost-benefit decision about whether or not they are prepared and able to endure what might possibly come." Title9forall.com is a massive resource for this issue. There are many cases on it. There are also help resources covering attorneys, how to file a complaint, helpful organizations. I would definitely encourage anyone who's gone through this or who's interested in the subject to follow up on that website and check these guys out. They did a massive in-depth study of this case. Kahn versus Yale, a momentous decision, a defeat for false accuser advocacy. The Connecticut Supreme Court said, contrary to the demands of advocates, campus assault accusers, including false and malicious ones, can be sued for defamation. We can and should seek justice for victims of assault, while also at the same time protecting due process and seeking justice for the wrongly accused. It's not a zero-sum game. But what happens when elite institutions and powerful advocacy groups disagree? Last November, they reported that a coalition of 15 accuser advocacy organizations, including well-known organizations like Know Your Nine, the National Women's Law Center, and Women's Law Project, filed an amicus brief, which means friend of the court, in Kahn versus Yale, demanding immunity from prosecution for campus accusers, including those who make false and malicious accusations in Title IX proceedings. As Casey Johnson noted, their amicus brief went out of its way to attack Kahn personally, including labeling Kahn, who was acquitted by a jury, a criminal jury, as an offender. So far did the brief stray that the Connecticut Supreme Court initially refused to accept it, granting them leave to refile, shorn of all the facts not supported by the record. So the Connecticut Supreme Court told them, look, you've got to make the facts correct, and then you can file this again with the court. They weren't parties to the lawsuit. They were just professional interested parties, but the Connecticut Supreme Court insisted you have to have facts and file facts with the court. You can't file things that aren't true with the court. As TitleLineForAll.com makes clear, a false accusation of abuse isn't merely name-calling. It's an attempt to destroy everything that makes life worth living. A good name, loving relationships, a decent job, a quality education, and more. While reasonable people can debate the exact boundaries of due process in an academic setting, whether courts should grant immunity from prosecution to abusers, including those whose preferred method of abuse is intentional and malicious false accusations, is where we should all draw a sharp line. Before the 2020 Title IX regulations granting increased due process protections went into effect, Yale student Saifullah Khan was accused of assault and expelled via a sham proceeding. He was also criminally charged but acquitted by a jury. In 2019, he sued Yale and his accuser in U.S. District Court for the District of Connecticut. Judge Carrie Dooley, a Trump nominee, dismissed Khan's defamation and torturous interference claims against his accuser-turned-defendant Jane Doe, holding that a school's investigation and adjudication, quote, constitute a quasi-judicial proceeding entitling Ms. Doe to absolute immunity as to any alleged defamatory statements made therein. Khan appealed to the U.S. Court of Appeals for the Second Circuit, and here's what the Connecticut Supreme Court actually decided. On Friday, June 23rd, the Connecticut Supreme Court issued its opinion. Not only did the panel of 7 Democrat-nominated judges unanimously reject the claim that accusers are entitled to immunity from prosecution for defamatory statements made in a Title IX proceeding, it went further to perform a laudatory guided tour of procedural safeguards that Yale failed to provide, as well as key due process decisions from various courts over the past 7 years. Quote, there are passages from this opinion that I suspect will be quoted in basically every accused student's brief moving forward. The decision is 39 pages long, but they summarize and provide quotes from the most relevant parts. From the opinion, a quasi-judicial proceeding for the purposes of affording absolute immunity requires sufficient procedural safeguards and to promote fundamental fairness, and the more robust the safeguards, the more likely the proceeding will be deemed quasi-judicial. Analyzing Yale's procedural deficiencies, the court held its Title IX proceedings did not have adequate procedural safeguards to be recognized as quasi-judicial for the purposes of affording absolute immunity to Khan's accuser. The procedural inadequacies Connecticut Supreme Court identified are as follows. Note that the opinion occasionally refers to Khan's accuser with the name D. No testimony under oath. D did not testify under oath or certify to the truth of her statements. She could not have been disciplined for failing to testify truthfully because she had graduated from Yale before the hearing, and those shortcomings undermine the reliability of D's statements in view of how fundamental the oath requirement is to the reliability of the information presented. No cross-examination or confrontation. The committee's procedures did not afford the plaintiff or his counsel a meaningful opportunity to cross-examine or otherwise confront D in real time. Those procedures hampered the plaintiff's ability to ask legitimate questions or sequence questions in a way that he believed would have tested the veracity of D's testimony, and in view of the importance that the opportunity to meaningfully cross-examine adverse witnesses has to be the truth-seeking function of any judicial or quasi-judicial proceeding. Since cross-examination is fiercely opposed by advocates for complainants, it's noteworthy that the court emphasized this safeguard. Citing Spencer v. Clementi, Justice Mullins stated, to qualify as a quasi-judicial proceeding for the purposes of the absolute privilege, a proceeding must, at a minimum, allow opposing parties to cross-examine, impeach, or otherwise confront a witness. The failure to provide a mechanism to challenge the veracity of testimony weighs heavily against the conclusion that a proceeding was quasi-judicial. The court noted that cross-examination benefits complainants as well. It is equally important, in our view, that the accused and the accuser be provided a chance to cross-examine one another so as to allow the fact finder to assess the consistency of testimony and demeanor of both the parties when their testimony is called into question. There was no opportunity to call witnesses. The committee's procedures did not afford the parties a reasonable opportunity to call witnesses, insofar as the parties could not independently call a witness, but were required to submit names to the hearing panel, which had the sole discretion to decide whether to call those proposed witnesses for questioning. No meaningful assistance of counsel. Although plaintiff was accompanied by counsel at the disciplinary hearing, the committee's procedures prohibiting counsel from submitting documents or arguing on the plaintiff's behalf, raising objections, or participating in the questioning of witnesses materially limited the assistance of counsel to the point that counsel was effectively rendered irrelevant. And those restrictions, although not dispositive, also supported the conclusion that the disciplinary proceeding was not quasi-judicial, or even an advisor. Under the UWC procedures, a party may be accompanied by an advisor, but the advisor may not submit documents, either directly or indirectly, on a party's behalf at any stage of the process, nor speak to the party during an interview with a fact finder or during a formal hearing. In practice, this meant that counsel could not present any argument, either orally or in writing, on Khan's behalf, raise objections, or be present during, let alone participate in, the questioning of witnesses. These restrictions effectively rendered counsel irrelevant, relegating Khan's attorney to the status of the proverbial potted plant. There was no meaningful appeal. When considering whether a proceeding is quasi-judicial in nature, we recognize a party's right to a meaningful appeal, which requires an adequate record of the proceeding, as an important procedural safeguard to ensure that facts were properly found and that law was appropriately applied. There was no access to records. There was no adequate record of the proceeding because the committee's procedures did not require the keeping of record statements, testimony, or questions. The hearing panel specifically declined the plaintiff's request that it make a transcript or other electronic recording of the hearing for the purpose of further review. The plaintiff's ability to appeal was severely constrained by the lack of a transcript or recording, and the restriction was especially prejudicial in light of the fact that the plaintiff's counsel was not permitted to object when members of the hearing panel allegedly assumed facts not in evidence or otherwise violated core evidentiary principles. Citations of appellate decisions. Justice Raheem Mullins favorably cited key appellate due process decisions from one state court and two federal courts. Doe v. Baum. In Doe v. Baum, the United States Court of Appeals for the Sixth Circuit concluded that due process required that universities allow for some form of live cross-examination when a witness's credibility is at issue in a school disciplinary hearing. Doe v. University of the Sciences in the Third Circuit. At private universities, as other settings, basic principles of fundamental fairness are adhered to when the students involved are allowed, among other things, to call their own witnesses. Doe v. Alley. California Court of Appeals, Second Appellate District. The California Court of Appeal reached a similar conclusion in Doe v. Alley, where there the court held that, quote, when a student accused of sexual misconduct faces severe disciplinary sanctions and the credibility of witnesses, whether the accusing student, other witnesses, or both, is central to the adjudication of the allegation, fundamental fairness requires, at a minimum, that the university provide a mechanism by which the accused may cross-examine these witnesses, directly or indirectly. Unfortunately, contrary to the above holding in Doe v. Alley, the Supreme Court later held that private universities are not required to provide accused students the opportunity to directly or indirectly cross-examine the accuser and other witnesses at a live hearing with the accused student in attendance, either in person or virtually. Guardrails on the court's decision. While much of the opinion was favorable to due process, the court was careful to establish guardrails on its opinion. For example, the court cautioned that not all such safeguards are required. Although we do not maintain that all of these procedural features are required for our recognition of a quasi-judicial proceeding, we conclude that the collective absence of such features mitigates against the determination that the proceeding had adequate safeguards to ensure reliability and promote fundamental fairness. Additionally, the court noted that while Khan's claims should survive a motion to dismiss, they may not necessarily survive post-discovery. Because this matter is only at the motion to dismiss stage, however, we must accept as true Khan's factual allegations in his complaint that Doe's statements were made with malice, which defeats Doe's asserted privilege at this stage of the proceedings. At a later stage of the proceedings, with a more complete factual record, it may be appropriate to revisit whether Doe's qualified privilege has been defeated. In summary, on the basis of the foregoing, we conclude that the UWC proceeding lacked adequate procedural safeguards to ensure the reliability of the statements made in the proceeding, and therefore did not qualify as quasi-judicial for purposes of absolute immunity. Campuses are not courts rhetoric. Should Title IX proceedings be quasi-judicial or not? Or perhaps more to the point, are Title IX proceedings only supposed to be quasi-judicial when immunizing false accusers from accountability and empowering schools to railroad accused students, but not quasi-judicial when providing meaningful procedural safeguards for accused students? Many schools and advocacy organizations, such as the National Women's Law Center, oppose the 2020 Title IX regulations, specifically the section requiring live hearings and cross-examination, on the grounds that Title IX proceedings under such requirements would be too quasi-judicial. The double standard regarding whether Title IX proceedings should be court-like has a long history in accused student litigation. Lastly, after Khan was found not guilty on all criminal charges, but before he filed suit in federal court, No less than 77,000 Me Too activists signed a guilt-presuming petition demanding Yale refuse to reinstate him. No one benefits from such extreme and one-sided advocacy. It is entirely possible to perform the vitally necessary work of advocating for victims without the bloodthirst of due process denialism and the zero-sum approach that to serve one class of victims and hold one class of abusers accountable. Another class of abusers must be allowed to abuse with impunity, and another class of victims must suffer without legal remedy. Anyone who would go after and damage another person or hurt another person needs to be held accountable. But they need to be held accountable in a system of due process where an accuser and an accused can get a fair hearing with the ability to test the accusations in real time in open court. I don't think this is something colleges should be handling whatsoever. Fact-finding is very complicated, and the stakes of what happens now to the accuser and the accused can be life-altering. In a country where we all have due process constitutional rights, it's really inexcusable to take those rights away just because you're in a different setting like a college. The education department should have no say over this. This should all be handled in the courts. To get more information on the subject and find more resources, and also resources that can really help, I would definitely suggest checking out TitleLineForAll.com. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.